Good morning, everybody. My name is John Giardinelli, and I'm Association Counsel. We're going to be doing something completely different this morning because we had planned on doing something in anticipation of the settlement forms coming out next week. But unfortunately, I'll announce why in a minute, that's not going to happen. So I know this is recorded and I don't know when you're going to look at it, but let me tell you that I am recording this at approximately 10:30 a.m. on June 21st. And this morning at approximately 8 a.m., the California Association of Realtors announced that the forms related to the settlement, the revised BRBC, the revised residential listing agreement, and all of the compensation related forms that had been drafted by the CAR staff that handles forms in anticipation of compliance with the settlement agreement are being held for an undetermined period of time, hopefully not very long. So we're not going to cover any of that today, but we are going to cover the other forms that will be released on June 25th. The reason is, and you all should get an email if you're a Realtor member. The reason is that the Department of Justice has raised certain questions about the CAR forms. I'm pretty comfortable that I know what those questions are. I disagree with them, but nevertheless, CAR is being prudent, which I agree with, and is going to, do what they need to do to make sure that everything is vetted properly for your collective protection. So what I'm going to do is I'm going to talk about the non-settlement related forms, and I'm not going to go over all of them because there's 41 new and or revised forms relating to transactions. So let me just kind of, oh, by the way, within the next couple of days, we'll be issuing a volume 2 newsletter. Volume 1 was in fact the settlement documents, and so we may need to revise that newsletter once we know what the changes are. Now, how we do that, we'll have a staff meeting at Tyler Law and we'll make that determination. But we'll do whatever we have to do to make sure that you guys have the most correct, up-to-date information as soon as we are aware of what that information will be. Okay, so take a look at the newsletter. Brad and I did a pretty good job, pretty well covered. You can read that over, but understand that those forms are not going to be released on June 25th, at least as of this moment in time. So what is going to be released? Well, there's, like I said, there's another 40 forms now. A lot of the forms are similar because of some things that are going on in the world. Number one, there is a new law that will go into effect on January the 1st regarding balcony inspections. We'll go over that in a little more detail down the road, but CAR has decided to, wherever appropriate in the RPA and some of the other documents in the seller property questionnaire, to include balcony related information. Secondly, on July the 1st, California is changing its security deposit law, and on residential security deposits, it will now be limited to 1 month with some minor exceptions. So they changed all the forms that relate to security deposits, the lease agreements, all the other forms, the occupancy agreements, and so there's going to be those changes. All of you are aware that insurance is a very significant issue in California right now and is affecting some transactions. They're going to be adding some contingencies, so they'll naturally have to add some contingency removals, and I'll go over that with you in a second. And lastly, as of July the 1st, there is going to be what we're commonly referring to as a flipper law, where if you've purchased the property within a certain period of time, 18 months, and you make some substantial repairs, there are some additional disclosures that you're going to have to make. And that means that modifications of certain documents, such as the seller property questionnaire, will be going into effect. So without hesitation, let me just kind of briefly, again, keep an eye out for Brad's newsletter, but briefly, they're going to amend the assignment of the agreement. If an agreement is assigned, they want you the contract will now default that the assignment is being done without compensation of any kind. And so obviously, if you're going to be paid for an assignment, that has to be specifically notated. The agent's visual inspection is being, a form is being revised so that the date, time, and weather conditions are all going to be put in a different location. And then there's going to be some additional language to make it clear that the agent, not necessarily the broker, completed the form. And then if there's some additional bedrooms and bathrooms, there's going to be some places for that. They're going to be amending the business purchase agreement, again, because of the balcony and stairs inspection law. And then they're going to add something in the business purchase agreement regarding insurance. The buyer's homeowner's advisory is being revised to add language regarding the difficulty of not only individuals, but also of HOAs to get insurance. The cancellation of contract is being revised to make it a little bit easier if the parties agree that the contract is fully canceled and the deposits are to be returned. So there's going to be some good language in there that will allow for an optional release of the full deposit without, and then there'll be some language if the parties are going to be paid out of that fund some out-of-pocket expenses. There's some changes to the contingency for the sale of the buyer's property that will allow us some additional choices relative to when the buyer's escrow closes. So that language will be covered again in the newsletter. The buyer contingency removal form is being changed because they have to include the contingency for insurance that will be added to the contract. So that, again, I'll go over that when I talk about the RPA in just a second. The designated electronic delivery at the end of there'd be a special form, but also at the end of the RPA that indicates whatever is included for the email addresses is going to default to the email where the notices to perform, demands to close escrow, and other notices during escrow can be sent. Cleans things up, makes it a lot easier for you guys. And so that's going to be taken care of. And then there's an interim occupancy agreement modification that will conform the lease to California law regarding the 1 month maximum security deposit. There's going to be a change to the market condition advisory because of insurance conditions in California. And there's going to be a change to the notice to buyer to perform that will allow you to demand that the insurance contingency be removed as part of the removal process. There is going to be some changes to the non-contingent offer advisory form that came out in December of 2022 that will add some language, making it clearer that if you remove a contingency and then the lender later changes its mind about the loan and you've removed the loan contingency, that will still make the buyer in default. So you got to be really careful about removing the loan contingency. There'll also be some changes to the advice given regarding removal of the insurance contingency. The property management agreement is being modified to take into account the new security deposit laws, and to also modify the rental property owner questionnaire, which is very similar to the SPQ. The residential lease after sale is also being modified because of the security deposit issues, and the residential lease or month-to-month is being modified again because of the security deposits. And there's also some language regarding who the exempt parties are in terms of getting more than a 1 month deposit. The statewide buyer advisory is being amended to include sections regarding both insurance and the balcony and stair inspection law that will go into effect in January. Of course, the security deposit exemption disclosure and addendum form is new, and it's going to allow for the property managers to do a much more explicit job on security deposits. The seller license to remain in possession is being modified. Typically, the seller is required to maintain the property when they lease it back, but if something comes up that is latent and the seller had no knowledge, it then becomes the landlord's responsibility. The solar advisory is being amended to allow for a disclosure of a maintenance agreement and the monthly payments for those maintenance agreements. The seller purchase of replacement property is being amended to allow for some additional changes and cancellation rights, as well as for return of some out-of-pocket expenses that the buyer might incur if the seller cannot find replacement property. The short-term rental agreement is being modified to clarify returns of deposits and cancellation rights. The septic inspection and well inspection being modified to default to the propane as opposed to other types of gases, and of course to be making clear that what's ever left in the tank is being transferred with everything else. The real estate transfer disclosure statement along with the SPQ are being modified because of some additional language regarding room additions, and also the flipper 18-month law. The TOPA agreement, the tenant occupied property amendment, being modified to limit if the tenant cannot be removed because of California and or local ordinance, then the buyer is entitled to cancel and get their deposit back along with some out-of-pocket expenses, but there will be a ceiling on how much those deposits are. The vacant land agreement is being modified if the owner cannot within a specified period of time provide proof of ownership. The verification of property condition is being modified regarding some clarification of some dates and recognition that someone other than the buyer conducted the inspection. There will be a wooden balcony stairs and other elevated elements inspection addendum that will be coming out. That form will become somewhat mandatory when the law goes into effect on January 1st. There is a water conserving plumbing fixture and carbon monoxide advisory that's existed for a while, and they're going to add some language regarding what the estimated costs are to bring whatever it is under compliance. And then lastly, there will be a modification to the withdrawal of offer regarding requests for repairs and some other issues, and Brad will cover that in his newsletter. Now, let's talk about the most important document, and that is the RPA. This is going to undergo some changes, nothing really significant. So I'm just going to list them for you, and then Brad will cover them. Obviously, the big change is in both the matrix and in the body of the document, there will be a standalone insurance obtaining contingency. Right now, that's part of the investigation of the property, which is confusing to a lot of people. And because it's become such a big issue in California, there's going to be an independent standalone insurance contingency. And so obviously all the forms I've mentioned, the notice to perform, the removal of contingencies, all those are being changed because they're adding that contingency. There's going to be some clarification on solar panels. There's going to be some changes regarding compensation to buyers. Now, whether they're going to hold off on releasing the RPA or remove that, I don't know. That was not told to me last night, so I really don't know. They're making the wildfire disclosure optional, so you'll have to check off a box if you're going to include that. They're clarifying what the seller is and is not responsible for on move out, and they're going to make it clearer that the seller is not necessarily responsible for spackling or covering up all the holes that are because of pictures and other types of artwork. Again, they're adding a section on the balcony disclosure. There's a warning, which I think is really good. Frankly, it's one of those, training wheel kinds of things that you should all know, that you shouldn't remove contingencies until the documents that you are waiting on have been delivered, but they're putting that in. And apparently some people don't know that. There is a fair appraisal advisory, and then as I mentioned before, they're changing some issues regarding the email delivery and making it a lot easier and clearer for you guys to do that. So that's the non-settlement forms. I sent Brad back his edits. Brad is one of the attorneys in the office that works closely with me, and I with him on a lot of this broker risk management stuff, and particularly this type of issue. And so we'll get that out to you hopefully early next week. Had a conversation with the Department of Real Estate, and one of the things that's been written about all across the land is that once this settlement goes into effect, the Department of Real Estate and many others believe that there will be an increase in dual agency. My next rant's going to cover this in depth. There's also going to be some available programs that are going to be available to you. But I want to remind you that dual agency means that you are going to have a fiduciary obligation to both the seller and the buyer, which means that it isn't just about disclosing material fact. It's about disclosing material issues. Now, one of the things I want to mention is that as we move into this post-implementation era for the settlement to commence, which is about August the 13th, for most things, we're still going to be trying to figure stuff out. A couple of experts have indicated, and I completely agree, that I think we're looking at a good, probably 6, maybe even longer period of time while people sort it out. We're going to have the bad guys that are trying to circumvent the rules. We all know that. But even more importantly, are people like you guys that want to do a good job, but there's a lot of questions. There's a lot of questions. And so the issue of negligence and duty is going to be something we're going to work through. As we learn things, we'll push that information out. So again, that's going to be a bit of a problem, is that what is the standard of care? We don't know what the plaintiff's bar is going to do with this. We know that they love dual agency because it's easier to sue a fiduciary than it is to sue someone who is not representing that particular party to the transaction. And as I mentioned, I spoke with the Department of Real Estate, and they are fully anticipating a spike in dual agency, which means that they're anticipating a spike in negligence, in misrepresentation, and in broker supervision issues as well. But it is perfectly legal, at least under current California law, Civil Code Section 2079. So long as you have an agency disclosure, you're good. You can do dual agency, but you got to sit down with both clients and explain what that means. Okay, it means a number of things. Number one, it means that you now have a duty to disclose all material information, and that you have a duty to disclose whether or not you verified that information, or at a minimum, you need to provide the source of the information. Could be a neighbor saying, hey, did you know the guy across the street is a sex offender? And we had a case like that not that long ago. There are some, and we'll go into this in a little more detail, but down the road, but there are some state statutes that do say you do not have to disclose certain confidential financial information. Why is the seller selling? Why is the buyer motivated to move into that area? Why is what is the buyer willing to pay? What is the seller willing to take? So there's some limitations, and you need to be aware of that. But you have to disclose more information, and what you have to disclose is based on a number of factors that's set forth in a jury instruction. One of them being the experience of the client, right? If you're dealing with somebody that has done many transactions versus a first-time home buyer or something like that, obviously you need to consider that as you approach representation. There's going to be a new form. I don't know if they're going to hold it. It is settlement related that will provide information to you that has to be delivered to you within 5 days after the execution of a buyer broker representation form that will give information such as how many homes, what level of sophistication. Then there's a separate form that talks about preferences. So all that's going to be happening. Y'all should take a look at Article 1 of your Code of Ethics, because as a realtor, you are obligated under the code and frankly under California law to put your client's interest primary. Now, if you have two competing clients, it makes it a little more difficult. That's why, statistically speaking, the highest level of litigation is against a dual agent. And there's a lot of them. According to the most recent statistics from CRMLS, about 10–11% of all closings were handled by dual agents. So it's going to be critically important that you properly document your file. The way issues are going to come up, for example, is if you're double ending the property, did you properly assist the buyer in looking at all of the available houses? During negotiation, did you take sides? Were you an advocate or a messenger? And then, of course, disputes that arise during escrow, got to be really careful about remaining a neutral and not taking sides. So all of this and more, much more, is going to become very important on a go-forward basis. The Department of Real Estate is going to be watching. The plaintiff's bar is going to be watching, and there's, as you know, a lot of uncertainty on a go-forward basis. So we're going to get blamed for things that frankly have never been done before, and that's just the way things are. So I think I'm going to cut it off for now. You've listened to me rant for long enough. So my name is John Giardinelli. I'm of counsel to the Tyler Law Group, and I will be seeing you the next time when we'll do something that is going to be relevant to whatever is going on at that particular period of time. So thank you very much for attending today, and we'll see you soon.